Good morning, everybody. Good afternoon to who is joining from China. My name is Alessio Pettino. I'm the business advisor of the EU SME Centre, located in Beijing. It is a great pleasure to welcome you to this webinar today about how to draft sales contract when exporting to China, an extremely important topic. And today I will spend a few minutes to introduce a little bit our center, the background of this report, and then we will move into a presentation from the author of this report, of a report we have recently produced on this topic. And then there will be a Q&A session at the end. Kind of change my slides apparently. Anyway, maybe before starting, for those of you who don't know the EU SME Centre, the EU SME Centre is an initiative, a project funded by the European Union, specifically under the Single Market Program. We have been around since 2010, so it's the 12th year, and this current phase is going to last until 2025. So we will be here for a few years. Our mission is to support European small and medium-sized enterprises, as well as entrepreneurs and startups, to enter the Chinese market, to get to know the Chinese market, or expand their activities if they're already here operating in China on the ground. We are implemented by a consortium of 6 partners and associated partners based both in China and in Europe. You can see them at the bottom of the slides. Among these, the Italian Chamber of Commerce in China is the leading partner and is also co-organizing this webinar with us today. Very briefly, we provide 5 main types of services. The first is the self-diagnosis tool, sort of quiz that users can take to obtain some insights, some tips about their level of readiness to enter the Chinese market. We have a knowledge center. Basically, we write reports, guidelines, case studies on different aspects. Could be sectorial reports or could be cross-cutting topics like this one today. We have an advice center, basically sort of help desk that people can use to ask any technical questions on any aspects of doing business with China. For instance, what kind of standards do I need? What kind of certification? What's the process to obtain this certification? My product is stuck at the customs and so on. We provide answers for free, absolutely free. Also through one-to-one calls. Training, we have a training center, basically either online or offline trainings like the one we are doing today online. And what's important is that on our website we have available the recordings of all previous training sessions that we did, so you can, if for any reason you miss some trainings, you can go to our website and see them. And last, we have an advocacy platform through which we try to update relevant stakeholders on new policies. We try to collect feedback on the implementation of these policies or comments on calls for comments on new policies published. So I mentioned we have this knowledge center, and as part of this this center, basically we produce reports and guidelines. And for this reason, recently we have written one on drafting sales contract when exporting to China. This is a very important topic because, of course, at some point sooner or later, commercial disputes might arise. But we see in our experience from the EU SME Centre that the focus is often more on solving disputes, which of course is extremely important. But we also think that preventing such disputes is equally or even more important. And especially in China, because enforcing rights, of course, everywhere, but especially in China, if you're an EU SME without a physical presence on the ground, is very difficult and costly and lengthy process. So we think we produce this report to increase awareness of the importance on preventing disputes, and this can be done through a solid, clear, well-drafted contract, which is not necessarily a very difficult issue for business, for basic business practices. It's can also be done independently, and this is why we produce this report. There are, of course, sometimes we see some transactions happen without contracts, with only purchase orders, but we think it's best to have a solid contract, and the reasons are because contracts provide more clarity of the obligations of both parties. They help to, therefore, as such, they help to prevent disputes because everything is more clear, and then they also provide an evidence that could be used to address case disputes, in case of disputes. This is the report that we have. It's completely free, can be downloaded from the EU SME Centre website for free. You have to register on the website first, and but then it's free. And in this report, we will see in the presentation, in the next presentation, we provide very detailed insights and tips about specific clauses, what clauses to include in the contract, which clauses are better to be formulated in what way, and so on. So it's a very practical tool. And yes, this is a QR code. If you want, you can scan this code to access the page of the report directly. As mentioned, you have to register on the website first, but it's free, and but it might take a couple of days to get accepted. Before moving into the core part of this webinar today, I would like to introduce Ms. Federica Vigiani, who is the manager of the China-Italy Chamber of Commerce, who is co-organizing this webinar with us today.
Thank you very much, Alessio. Thank you to the center. It's always a pleasure to co-organize activities together. I'm here today just to briefly give an overview of our chamber for those of you who don't know us or you're not member of our organization yet. So in next page, you will see a little bit like where are we present in China. We, as a China-Italy Chamber of Commerce, we are the only business association that is both recognized by the Italian ministry and by the Chinese ministry. And last year, we celebrated our 30th anniversary from the refoundation of the chamber with over 800 members. We've been growing constantly in the last few years, thanks to the fact that we are present in the main territories in China. As you can see from the map, we have 7 offices in China in the main regions. And of course, we are part of the Italian system here in China. So we promote companies that are part of our network, and we promote Made in Italy here as our main business scope. If you're interested in getting in touch with us, please don't hesitate to do so. In the next slide, you will have a recap of all our contacts. I'm talking from our headquarters in Beijing, but again, we have 7 offices around China, as you can see from this last slide. So nothing more from my side. I just want to greet you all and wish you a good webinar. Thank you, Alessio and EU SME Centre.
Thank you, Federica. And so now we can move into the presentation, central part of this webinar. I would like to remind you that there will be a Q&A session at the end. There will be plenty of time to ask questions. But of course, if in the meantime you already have questions, please submit them in the Q&A box of Zoom, so that that those questions will be answered first. So now it's my pleasure to introduce Mr. Daniel de Prado Escudero, who is a partner and legal counsel at HFG Law and Intellectual Property Firm, which is a very well-recognized firm operating in China and Europe. And Daniel has worked as an expert at the international desk for this firm, but also in general in Chinese, has been dealing with Chinese legal issues for many years. And he's one of the best experts around on this topic of the sales contract. So it's my pleasure to have you here, Daniel, and thank you for your availability. The floor is yours.
Thank you, Alessio. Thank you to the EU SME for organizing this webinar. Just to give you a little more comprehensive explanation of the guidelines that we recently published about how to negotiate and draft sales contract in China. I will say share now my screen, right? Go into presentation mode. Okay, so well, this is thank you for your kind words, Alessio, as well. About HFG, about the firm that I have the pleasure to work with here in China, just to mention a few things about us, for you to understand who we are and how could we assist you, or if you have any issues in China or thinking to develop your business in China. We are a Chinese firm. We have offices in Shanghai, Beijing, and Tianjin. And we are around 90, 100 professionals from different backgrounds, but mostly legal and scientific background, of course, as we are very specialized firm in intellectual property matters. So that is one of the main fields we touch. We assist companies, mainly foreign companies, developing business in China to protect their rights, IP rights, and their interests when they develop their businesses, their projects in China. We also have another main field in which we work and provide services for, which is obviously the corporate side, and contractual assistance to also local, but mainly foreign companies as well. And finally, we have a very small but very specialized technical department, very focused on the food and beverage sector from a regulatory point of view, in which we provide as well services to advise companies on how to approach the Chinese market, Chinese food and beverage market, and not to get muddy in some aspects of the regulations. The Chinese regulations and laws that are quite different from to other markets, like it can be in Europe or the US. And in that regard, it is necessary to carry out a comprehensive analysis before we jump into the Chinese market. So I will not delay more. I will just jump into the today's topic. I always like when we do this presentation for a foreign audience, which I think it's the case of today. I like to start my presentation speaking a little bit more about China. So put things into context. And because the feeling we have and the feedback we have from some also colleagues, the professionals in the sector working in other countries, is like China remains very unknown for the world. Even though it can be the second major economy nowadays, it's present on a daily basis on the news, that the Chinese culture, practice when it comes to develop their business there, to understand how to approach the Chinese market, we believe, and it's the sense and the feeling we have and the feedback we receive from many clients, that it remains very unknown, very not well known how to approach the market, how to negotiate, how to treat and handle dispute with Chinese partner. So I always use these two paragraphs. It's an introduction taken from a book written by my colleague Nicola Porti about introduction to food law in China. But I think it's very graphic and very specific of what are those issues that you will find in the Chinese market, and you will find in China, and nobody takes or pays attention to it before. So I will just read it, because it says that the main mistake, and unfortunately also the most common, made by foreign companies when starting the development of a business project in China, is to underestimate the enormous differences between our countries or other emerging markets and China. We need to be aware that China is different. It's a world apart in many aspects, and in many ways featured by unparalleled complexity and unique distinctive peculiarities. So now there is no room for improvisation in this market, and this is something that we learned, or many companies have learned, sometime developing their business in China with their projects in China, and not understanding this or not taking into account these differences. Comparing China to other countries means losing the battle beforehand in any project that we may start in this country. So that is essential. It's crucial, it is key that we try to understand a little bit more about China, and before we develop our business into the country, before we start thinking of bringing forward any project that we may have for China. And I I like to use also this slide, this kind of comparison between Chinese market and the jungle, right? So because for many companies, China may be a gem in terms of business. We understand that, and we understand the opportunities, but also it will be kind of a jungle where you will have to defend your rights and your products, sometimes in a very aggressive way. Chinese companies act very quick. If they see a business opportunity, they don't hesitate. They just go ahead with it, and sometimes in a very aggressive way. And that's why we said and we stress always that we need to be aware of that. And you will have, as a company, especially as an SME in China, to defend constantly your product and your rights in the market. And this that can be seen as a part of videos, can be a kind of fun slide. It is not that fun if we put it into context and we see what happened in reality, like unfortunately, as a result of the pandemic, these last 2-3 years, where we saw not companies, not SMEs, not even big multinationals going into the Chinese market, but the government, national governments, going to China to purchase, to make the acquisition of face masks and other health products that they needed. And they got involved in terrible, actually, cases of frauds, of poor quality products purchased in a very terrible situation and moment. And for us, that we were at that time when we were in China, seeing these things that were happening in Europe with national governments doing business in China in this way and not being able to take necessary measures to understand the market and to understand the measures that they needed to take in order not to be frauded or not to be cheated. It was very, very sad. So I like to stress this fact because it is actually something that it can be avoided. But like I said, we need to make an effort to understand better China from a cultural perspective and the Chinese market in the way our partners can act and what we can expect from there, not to be surprised afterwards. So, well, I'll just jump in now into the core part of this presentation, also of the guidelines. We'll be talking about drafting sales contract when exporting to China. So how to draft, how to negotiate a sales contract in China. And as I said, this pre-contract stage that I mentioned before, it's crucial for us to conduct our business in the safest way possible. So what are the tools we have? How to check the status of a potential business partner to understand whether or not it can be a safe partner, it can be a good deal to move forward with that project? Well, we have actually some ways which are not complicated at all. And we just need to understand that it is very, very important. It is crucial for us to do it in advance. So once we have developed some conversations when a potential business partner, we need to understand that. We need to carry out due diligence, actually, to verify the reliability of our potential business partner. That is the first essential step that we need to be aware of. How to do that? How to verify the legal status of the company in China? Well, actually, nowadays it's quite simple. It's not complicated at all, because corporate information regarding Chinese companies is available to anyone, to any third party, by means of public and private sources. So just by conducting simple searches on those databases, we can easily obtain relevant information about our potential business partner to assess not only its reliability in terms of financial capacity, for example, but the basic points of whether or not this company is duly incorporated in China. And it can be seen as, okay, how can they not be incorporated? Well, that happens to us in the past many times. So that's why we try to point out and to stress these basic principles that we need to be aware of before moving forward with the contract with a business partner in China. So we can check the existence, the incorporation of the company in China. We can check the status and nature of the company, and whether they have been involved in some litigations, and moreover, especially if we are large-scale deals, it is highly recommended also to obtain a credit or financial report of our potential partner. And this way, we may also assess, like I said, the financial status of the Chinese companies and the financial capacity to pay us. In the guidelines, you have a very comprehensive explanation of how to do this specifically. In this case, I just wanted to highlight the importance of this pre-contract stage and this due diligence that we need to carry out once we know or we have got into contact with a potential business partner, and how this step is crucial for the development or the performance of our business afterwards. So just to mention a few points that they need to be tackled and they need to be verified, and just to check whether these potential partner well, they have the qualifications to provide services in China, or at least to sell the products that we want them to sell in China, because they have obtained their mandatory qualifications, required license, etc. Whether this company has been blacklisted, that is something that can be easily checked as well. So that is another thing that we need to take into account. And finally, as I said before, whether this company, this potential partner, has been involved in litigations before, or what has been the object of those litigations in the past, to understand a little bit more what we can expect from this potential partner in the future. So therefore, these factors, these situations are worth considering before cooperating with a company, so we can see the background of the potential business partner and the operations that they will be able to carry out. Just to offer you an actual case, a practical example that we saw in the past, and this is why I mentioned in the beginning that first thing we have to do is just to verify whether this potential company is actually duly incorporated in China, because it happened to us in the past that a client came to us. They wanted us to provide services for due diligence to verify this legal status of the companies they had interest to develop their business with, and we asked the client to ask the business partner for the business license. Is the way we can ask in China, where we can verify the details of the company. We received the business license of the Chinese company, and we went to the registry. It happened to us that we confirmed that this company had been liquidated 1 year before. The company was not incorporated anymore. It had been dissolved, but they were still doing business and offering their services to European, to foreign companies in China. So this is why I said we need to be very cautious and conduct this due diligence in advance, because these things tend to happen more than we expect, unfortunately, and we need to be very aware of them. So I'll move now to the part of the contract. So how to draft a contract with a Chinese company, how to negotiate. I'll be just mentioning a little bit, few tips that they are more developed or more comprehensively developed in the guidelines that you can read. I'll now just mention a few points, like, and this is a very specific part of the Chinese culture, and that's why I mentioned it's very important for us to be aware of this taking this step. Because if we see ourselves in the negotiation with a Chinese partner, we need to understand how different they behave and how different they are culturally speaking. So we need to learn more about our counterparty, like I said in the beginning, before we start the face-to-face negotiation, and research our potential business partner background. And also in Chinese culture, cooperation is very important. So kindly, we contact the counterparty, when we contact our potential business partner, we need to stress out this cooperation for purpose. This is something that they will value and they will appreciate. Also, in the business environment in China, formalities are very important, and that is another thing that we need to take into account and learn about them. Small talk, like the key point as well, where if we are going to meet up face to face with your business partner, according to Chinese culture, a good beginning always comes together with food. This is something that if you have been doing this in China, you probably have already learned. And initiate a small talk to warm up the negotiation for a few minutes before the food is served. So everything happens before a table with food, and then business comes. Then describe the cooperation plan in detail. Like I said, always talk, if possible, in terms of cooperation. Making a detailed description of the cooperation intention, cooperation procedure, cooperation content. It's all about gaining the trust of our potential business partner. And finally, one specific aspect that is very important for Chinese companies, and it's crucial, is the method of quotation. And you may say, well, it's important for every company all over the world, right? Yeah. But in China, it's true that you have negotiated previously with Chinese companies, the ability to offer specific and special discounts, you will see that it works and will ease any agreement with them, just to make them believe more special, or that you have intentions to build a long-term relationship with them. And this is a way we can ease things and ease negotiations to reach a better result. Okay, and I will just now go ahead with more legal side of the presentation, and also, well, as you can see in the guidelines, just for me to mention a few key formalities of Chinese contractual practice that are completely different from what we see in Europe and what in the contractual practice, and are essential to be understood in case we need to jump into the drafting of a contract in China. Like I said, there are a few particularities of China contractual practice and legal system that must be duly considered when we are going to draft the contract with a Chinese company. And keeping that in mind will allow us to protect and secure the validity and enforceability of the contract, which is the most important part of the result of the contract. So one of those peculiarities is absolutely the CHOP, the official corporate CHOP of Chinese companies. Any contract that we sign in China must be CHOP with this official corporate CHOP. It is this red rounded CHOP that you can see here on the right part of the screen. Every Chinese company has one official CHOP, and that is what binds any contract to a specific company. In Europe, we are used in the practical and the legal system to sign contracts by the legal representative, for example, and this is what makes the contract binding to the company. But actually in China, it doesn't work like that. The signature of the legal representative is not necessarily binding for the company, and sometimes it cannot be, especially if we are not sure if the person we are dealing with is the duly legal representative of the company. And therefore, this is something that we need to remember, that we need to have the Chinese company to CHOP the contract with the official CHOP. This is one of the few key aspects that we need to remember. Then the Chinese name, Chinese names of Chinese companies, that we need to include them in the contract, and that is essential. Even though the contract is all in English, we need to stress the importance of having the Chinese name there. English names of Chinese companies are not official in China and tend to be made up. Chinese companies just randomly choose nice names just because they sound more fancy or they sound more innovative, or they just pick names many times randomly, and they use those names, these English names, to do business with foreign companies because it's easier for the foreign company to recognize. So we need to be aware of that, because sometimes we go to check the English name in the Chinese registry and there's no any trace of it because it's just a made up name. So Chinese names of the companies are essential and they need to be included in the contract. Otherwise, we may just end up with the contract that it is actually executed with a company that it doesn't exist, because we cannot trace who that company is. And there's just a few mentioned the original version. Always obtain and keep an original version of the contract. You sign and chop by both parties, just because in case we have any trouble, we're gonna need it. And if we need to go to court or arbitration court, we're gonna need the original version of the contract. And this is a little bit different from what we see in the practice in Europe nowadays. And finally, bilingual agreement. Ideally, it is highly recommended to have a bilingual agreement, Chinese, English, usual, just to avoid further misunderstandings and drawbacks with translations in case of litigation, and also because it gives the counterparty the perception of that we know where are we getting into, that we know China, and having the contract in Chinese that put some pressure on them that you know, as a foreign company doing business in China, that you know how the environment in China is, you know the market, and are willing to go ahead with them in that regard. And that is important to transmit the counterpart a sense of we know where we are and know what we are doing. So now we'll just focus a little bit on the most important provisions of that need to be included in a sales contract in China. I will not talk very much of each one. We'll just make a kind of summary, just highlight the basic principles of them, because you have a very comprehensive explanation and of each clause or provision that needs to be included in the contract in the guidelines that you can go through them. And so I will just now highlight those basic principles. And from an overall approach or perspective, we always say the same. We tend to focus on basics, things, and basic aspects of the contracts that we need to consider and eliminate unnecessary details. Contracts in China need to be simple, clear, and precise. Those are the basic principles when drafting a contract in China. I believe it is better to avoid the standard common law agreements, not because they're not good, they're fantastic from a technical point of view, but just because they're sometimes too detailed, too long, and the Chinese parties are not very happy sometimes to see very long contracts. So we tend to use, or better tend to use, simple and straight contracts, detailed enough to cover all the risks, but not too much. So this is important. And state and doubtful obligations. So who shall do what, when, how much need to be sold to the counterparty. So make these basic aspects very comprehensible and the explanation clear for everyone that can read the contract to understand what are the obligations of the parties. Penalties for breach of the contract or of the obligations, so they include it, and not because we may expect to receive this money in return in case of breach of the contract by the counterparty, because these penalties can be subject to moderation by the court, but actually because it works many times like a kind of coercive measure or method to the counterparty. So if they see a clear penalty for the infringement or for the breach of specific obligations, they will think twice before they don't comply with it. And that way it can be very useful to include in the contract. And finally, well, POs, purchase orders, just for you to know that are acceptable in lieu of contracts, but so have clear details. They need to include all the details of the deal, of the business cooperation, and must be in original paper and shown with official chop of the Chinese party, like I said in the beginning. Then the product description clause or provision was just to stress that the description to be included in the contract must take into account the frequency of the sales and the scenario in which the parties will perform their obligations. You have a full explanation of every detail in the guidelines that you can check, but just for you to know now and to keep in mind that the wording and the regulation that we will use and we will state in the contract should not be the same for a one-off sale than for a regular provision of goods to the buyer, that is the Chinese company. That makes a difference and need to be regulated appropriately in the contract. So that is the most important point of this clause, that for you to, when you are facing this, the drafting of this clause, to think about it and try to describe how the product will be commercialized in China. And then describe the purchasing process provision. It is essential, actually, to include a detailed description of how the product shall be ordered by the Chinese party, and when such order will be considered as accepted by the seller, how will the purchasing process take place. Need to describe that in a, like I said in the beginning, in a very simple and easy way, but clear enough for each party to understand their obligations in the process. And even though this may be seen kind of confusing initially, so the description of how the purchasing process will happen, it is actually quite simple and effective, as it will clearly define the procedure to be followed by the parties. And then when it's clear, we will be attached to it, and it will be very or much easier to solve any dispute that may raise during the performance of the agreement. So that is another important or key part that we need to consider. Then, of course, payment terms and the consequences of potential breaches. In the guidelines, you may see the different payment terms or methods that are most common in China, or usually are chosen by the parties when doing business in China. I will not go through all of them now, but the important point for me for this clause, for this provision to understand is, whatever the method finally chosen is, whatever the method of the payment, it is essential to define as clearly as possible what exactly the agreed price includes. So all the concepts, all the aspects needs to be specified. In particular, that all payments due to the seller are paid net and without deduction of taxes, custom fees, or other charges of any nature that may arise. And that is very important to make it very clear, because it's the kind of thing that we've seen so many times as a common source of troubles and disputes between the parties in a contract. And many times as well use this thing by Chinese companies to increase their fees or deduct some money from their payments, claiming that, okay, no, but we didn't specify that the customs duties were included in the fees we agreed, and therefore we need to deduct that. And they use that as a negotiation tool. So it is very important to clarify that, to specify each aspect of the fees, and then the total amount that should be paid net and without any deduction finally to the seller. So of course, in case of partial or total breach by the buyer of its payment obligation, another point just to keep in mind is that we should grant, and we should specify that and draft it in the contract. We should grant the seller the faculty to suspend the performance of its obligations in the contract, included but not limited to the delivery of the products until the buyer fully complies with its payment obligations. Why? Because otherwise we may see ourselves involved in a situation, in a scenario in which I am selling them goods, they are not paying me, or they didn't pay the last installment, and I still have the obligations to keep providing them the products as agreed in the contract, even though they haven't paid. So that is important also to be another key point to be included in the contract, just to avoid us or that we see ourselves in this kind of situation. Also, I guess I also mentioned this before, but we can also set out penalties to the buyer for late payment as a coercive method to push the buyer to comply on time with his obligations. Delivery clause, so delivery of the products to my partner in China for him to sell it or sell them in China. And for this, I will just stress how we need to describe how the delivery will be carried out, and especially the process, the periods, and liabilities in case of any breach of the obligations. The special mention and I want to make now is the transmission of risk, and also to the use of Incoterms in the contracts that will actually will ease the understanding of the obligations of the parties and will provide more certainty of the obligations of each party. The Incoterms will govern the allocation of responsibilities in case of any loss, damages, breach of the conditions agreed, etc., etc. So I would recommend to use them if possible, or otherwise, if not, we need to be aware of that we need to define, specify the process that in which we use the delivery, or how it happened, or how it will happen, the periods and the liabilities of the parties. The obligation of inspection upon delivery, which actually basically is just review of the quality standards and quality control procedures. So state clear procedures that once the products have been received by the Chinese party, that they'll have the obligation to confirm that everything is in order and correct and as agreed in the contract, complying with any technical detail or quality standard, etc., etc. Because this is a way, and by regulating this, we will prevent our business partner to raise ungrounded complaints over the quality of the products, for example, or even use such argument as a countermeasure in a dispute over a potential breach of the buyer. And this is something that we have seen very common, that we have seen so many times in the past in deals involving foreign companies and Chinese companies, that the Chinese companies tend to use, so they don't comply, for example, with their payment obligations, and when the foreign companies raise a complaint about it, they come back to them saying that, okay, but now the standards or the quality of the products we receive did not comply with the specifications we did in the contract, for example, but as we didn't include any specific provisions for inspection upon delivery and confirmation of the goods or the compliance of the goods with the terms of the contract, we cannot use it as an evidence to say, yes, did the quality of the goods, you confirm the quality, you confirm the standards, so everything was okay. Now you have to pay. And if you don't pay, we have the tools to act against you to enforce our rights in the contract. So this is the most important actually aspects that we need to keep in mind, and why, or the reason why we need to include this clause in the contract. And now I will just mention and go to a very specific clause that often is very underestimated by foreign companies when doing business in China. It's the intellectual property side of the contract, and when it comes to sales contracts, mostly protects trademarks and designs, or the designs of the packaging of the product, for example, if it's very representative of the product. So protecting your trademark and those distinctive signs of your products in China should be one of the first, also crucial steps to be taken by any company aiming to develop this business or sell its products in China. And as I said, unfortunately, the protection and registration of those assets, so the trademarks or the designs, is many times ignored or overlooked by foreign companies when facing the Chinese market. Many times unaware of how the lack of proper legal protection may define the success or failure of their business in China. And it is absolutely true. We've seen projects and sometimes big projects or trade deals that didn't go as expected or were completely unsuccessful because the companies were not able to protect their trademark in China, because the Chinese partner used it to protect and register the foreign company trademark in China, and then blocking the market to the foreign company, even if it is their trademark, the one they are using. So for us, first step that we need to be aware of is we need to understand how will I commercialize my products in China, what are the trademarks that I'm going to use, the distinctive type that I'm going to use, and then conduct a check to confirm whether this trademark can be also already registered in China by a Chinese company many times, which is very common. And then we will need to take actions to retrieve the ownership of our trademark in China. And once we have our trademark protected and registered in China, we need to be aware of that point, specify that in the contract and provide a license for our business partner to use it under certain limitations in the performance of the contract. So just for you to remember and to keep in mind, intellectual property trademarks need to be taken care of. We need to be aware of the importance of these aspects when we develop the Chinese market. And this is one of the main issues that foreign companies face when approaching the Chinese market. And this is crucial for the successful success of our business. And finally, well, important provisions. We have the important provisions clause, the applicable law and choice of forum. This is very well explained, very comprehensively explained in the guidelines. So I will just mention that companies find themselves many times in the position to choose between Chinese law or foreign country law to regulate or to rule the contract. And in our case, that we see it's more effective if we are doing business in China, if we are going to work with a Chinese party. What we want is to get paid in the end. We are selling products there, we want to get paid, and if that doesn't happen, Chinese law is usually more effective in credit collections if we need to act against a Chinese company, and therefore it will be more efficient if we state that in the contract, especially in order to enforce any potential judicial decision afterwards. Therefore, we recommend using Chinese law to regulate or to rule the contract. And then with regards to the competent court, we will need to decide, we will find ourselves to decide, okay, shall I choose arbitration? Shall I choose ordinary courts in China? In this case, we see many times that for foreign companies are not very aware of the efficiency of the Chinese judicial system, which works much better than we expect many times, or at least in the way that foreign companies tend to see this. And I think we believe the arbitration is advisable for high volume or very technical or complex contracts, and that it can be the scenarios or situations in which arbitration can be chosen. But otherwise, and especially for SMEs, we recommend choosing ordinary courts in China because are faster, inexpensive, and more reliable than usually perceived by foreigners. Legal procedures in China before courts are actually quite quick and efficient, especially if we compare that to some European countries that are, the judicial system is very slow. The first instance will take 9 months to obtain around 12 months to obtain a judgment. And there's good quality of decisions, and probably the cons are like well, it's sometimes too formalistic system that we will need to notarize all the evidence, but that will happen anyway in arbitration. So we believe that in those cases, courts as a dispute resolution option will be a better choice. For arbitration, like I said, it is advisable if the scale of the contract is very large, or we are before a highly technical deal, and especially when usually I tend to mention, I tend to stress this fact. We need to avoid institution of arbitration institution in Hong Kong, Singapore, London, or Paris, unless we are before a $10 million deal. Otherwise, these procedures in these institutions are really very, very expensive, and resulting in the way that we will not be able to enforce our rights, because we will see that probably the cost of the procedures is higher than even the claim or the compensation we are claiming as a result of a breach of the contract, and therefore the contract will become non-enforceable. So it is important that we keep that in mind, and we make a good choice when deciding between local courts or arbitration institutions. And to put an end to the presentation, I'd just like to mention, well, practical tips that we need to keep in mind during contract performance, and that will help us to give better responses and obtain good evidences if things go wrong. Every modification related to the performance of the obligation shall be notified in writing by email. So if we change during the performance of the contract, we change any terms, any agreements, we need to make that in writing by email, and make sure that the email we use with our Chinese partner is recognizable, because we will need that in the future if we need to enforce any rights in the contracts, because there has been a breach by the counterparty. They need to recognize, and a judge or an arbitration institution will need to recognize who the counterparty is. And in China, it's very useful. It's very usual to that Chinese parties use emails like the one you can see here, like QQ.com, which is a service provider, and it's just so there's no recognizable person behind that. Not because the name is not included, but not the name either, the name of the company. So if we have that in writing, okay, we may have an evidence of the what we agreed with the counterparty, but the counterparty is not recognizable, so it will not be useful in the future. So we need to be aware of that and try to convince the counterparty to use recognizable email addresses that we can use as an evidence in the future in case we need to enforce any of our rights. About evidence collection, well, it is essential, like I said, to collect evidence following certain formalities. It is a very formalistic system, the Chinese one, and then we need to be aware of that. The delivery of the product shall always be traceable. So the original documents on paper, sign and chop, like we said, all these formalities are essential. That the delivery of the documents will state very clearly all the specifications, like we mentioned before. And again, that course will not consider copies of the contract as evidence. Therefore, we need to have the original in paper and chop with the official chop of the counterparty. If at any point things go wrong and we are not able to provide or to obtain an amicable solution, well, get legal advice as soon as possible will be the most appropriate thing. Evaluate the situation and evidence of the counterparty's infringement, and then define a strategy to put in motion any action to defend your rights and interests. The delivery of an attorney letter from a Chinese law firm to request the counterparty to comply with its obligations in the contract in case of breach should be the first step to compel the counterparty to meet these obligations. And I say from a Chinese law firm, not because I work for a Chinese law firm that you may think, but because especially some Chinese companies take advantage of the usual lack of knowledge of foreign companies, like I mentioned at the beginning of the presentation, of the Chinese legal system and the practice, and think that the foreign partner will not take any legal actions because they don't know China. And this is a very common phrase used by Chinese company. You don't know China, and therefore they don't feel compelled to meet their obligations in the contract. Well, when they receive these letters from a Chinese law firm, from a Chinese lawyer in Chinese language, then they realize that the counterparty, the European company, is aware of the system, knows the practice, and is willing to take action against them. So that will put some pressure on them and make them understand that the foreign partner is actually duly assisted in China and will be able to enforce their right in the contract. And well, if in any way none of the above works and the dispute over the agreement cannot be solved, we will still then be forced to file a lawsuit against our business partner as a result of the breach of these contractual obligations. And just to, well, I call it a wise summary to put an end to it, because I like it. I like these kind of rules of business in China that I call it, and I found this slide a long time ago. But I think I think it was in LinkedIn, and it's a very, very good description of these particularities of China from a cultural perspective and from a practical point of view. And it says that everything is possible in China, which would be the first rule, and it's true. There's always a way to find a solution to everything. We just need to find out which one. That nothing is easy, and the patience is the key to success. This is essential. This long-term is crucial in China. Many business partners in the Chinese culture and also in the business environment, long-term is the key to success. So we need to be patient to get to it. That the answer yes is not necessarily an indication of agreement or confirmation, that we need to read behind or see behind these scenes and understand what is really going on. That provisional regulations means the rules can change at any time, even retroactively. And this one, as a lawyer, I love it because it's just so real. It's signing a contract means the beginning of the real negotiation. And this is something when we need to take into account. We need to understand that it's part of the Chinese practice and culture when negotiating contracts. That it is something sometimes that we cannot understand from our European mindset, that you sign a contract, those agreements or those terms are therefore sealed and they cannot be changed. It doesn't happen like that in China very often. So we, rather than frustrating ourselves when we see our counterparty coming the day after we sign the agreement saying, hey, but I'm not really okay with these terms that we agreed with. Okay, rather than, again, being frustrated, just let's adjust our behavior to the Chinese practice and offer solutions to the counterparty. So just be prepared for that, because it will happen. And that finally, when you are too optimistic, think about rule 2, that nothing is in China. So be careful, be cautious. And then when you are discouraged when doing business in China, think about rule 1, that everything is possible in China. And we just need to find out the way to get to the solution. That's it on my side. I think we have the questions and answer section now. And well, in case you may have any questions in the future as well, you may contact us for anything which we can assist you with your projects in China.
Thank you, Daniel. Thank you for the great presentation. I would like to add that we just focus on general aspects here, but in the guidance that we have really the specific examples of specific clauses that you can use for each of these elements that were just illustrated by Daniel. So both in English and in Chinese. So I invite you to go to download the guidance. I also planned, if you can stop sharing your screen, please, Daniel. I had also planned to say a few words about due diligence and things, but I'll just say that we, a few months ago at the EU SME Centre, we also wrote an article about how you can do background checks on Chinese partners, how you can identify some red flags of potential, let's say, risk. It was mostly from the perspective of buying from China rather than selling to China, but I think it applies equally because it shows what characteristics some unreliable partners have in common. I would now jump into the Q&A immediately because we don't have much time left. There are a few nice questions that I see. I would begin with one that says, I experience sometimes electronic chopping. Is that equal to the original version? Because it was said in one of your slides that you need an original copy. And maybe if I may add, considering that maybe a company is present only in Europe and the buyer is present in China, if you have to ship all the originals, sometimes it could be quite an expense. So,
yeah, I understand. But it's still our recommendation, our suggestion is to obtain the original contract if possible. Otherwise, if there's an issue in the future, and we need to enforce our rights in the contract before a Chinese court or an arbitration institution, we will need the original contract. The scanned copy or the digital version will not be accepted. Therefore, we need to understand the importance of having the original one. Even though if we need to ship it, we need to spend $100 or $50 to get it, I think it may worth it for the future.
right. Another question that I received is, so we mentioned about the chop that needs to be legal, needs to be official, needs to possess certain elements. What if I realize that the chop that was used by the company is not the legal one, but I realize it only afterwards? So we have a contract, we have the transaction, then there is a dispute, and I realized that the chop used was not the right one. What can you do on that? And how likely it is that a court will recognize that contract with a fake, like, kind of chop?
It's difficult. If the chop is not the official one, well, we may use other evidences to prove that that contract should be binding for the company, but it will be hardly accepted by the court or an arbitration institution. Like I mentioned, this official chop is the only tool that binds the company to a certain obligations stated in the contract, and therefore it's mandatory. If the chop that we see is fake or is not the official one, well, if we are still on time, we can ask our partner to chop it again, just using any example, saying, hey, well, we realize that the chop you included is not the official one in China. Please, can you do it? Can you include it in the contract? If we're still on time and there's a way, we have to ask. It's essential that we do that. Otherwise, if it's too late or there's already a dispute over the contract, what we can do is just try to obtain evidences or other evidences, alternative evidences to prove that this specific company, by other ways, like I said, emails, conversation exchanges, invoices, for example, use other evidences that we can collect to prove that it was this company behind these actions, and therefore we are entitled to act against them. But it will not be easily recognized by.
Right. Okay. So it is also vital to know the specific name in Chinese of the company, not the English name, because this, it's not official. Yes.
Absolutely. It's not official, and like I said, it's made up many times. They just choose or pick random names just because they're fancy and they believe are more appropriate to do business because it sounds better, and they use it. But many times the English name has nothing to do with the Chinese name. Absolutely not. And therefore it doesn't exist. You go to check this English name in the database in China in the registry, and it doesn't exist, obviously, because it's not official, it's not recorded. So it's essential that we include the Chinese names in the contract, even if the contract is only in English.
Right. And by the way, this is also one of what I was referring before with red flags of potential risks. Sometimes we see transactions done only with English names, and you don't provide the Chinese name. So maybe this might indicate potential, let's say, bad faith in transactions.
Exactly.
Yeah. Another question I have is it the signature on the CHOP mandatory, or just the CHOP, or?
Well, if it's for the European company, it is mandatory, because according to the local laws, it's the way that the company is buying the contract through the signature of the legal representative, because he has or she has the capacity to represent the company. But in the case of the Chinese company, it is not necessary. We need to have the CHOP on the contract. That is the binding tool of a contract in China to a company, and we do have that. If we also have the signature of the legal representative of the Chinese company, great, fantastic. We can also include it, but we need to have the CHOP. That's the most important.
Very good. One last question that I have says, is on your last slide, actually. Signing a contract means the beginning of the real negotiation. So the question is, does the result of such further negotiation needs to be updated in the existing contract through amendments or?
Absolutely, yeah. It's a great question, because I think it goes in line with what I mentioned about what can I do during the performance of the agreement to protect myself for the future, right? For any potential issues that may arise. And this is one of it. It's any change to the original terms of the contract, to the original agreements, it needs to be stated in writing and confirmed by the counterparties. And if we do that in writing, in just an amendment to the contract, excellent. It's the best way. And then again, chop it again, so everything is clear. So the new terms are clear. Both parties are aware of them. And also we have evidences, we have proofs that we can use in the future in the case of any potential dispute to prove that, hey, yes, this was the original agreement, but there was a later change of orders or change of decisions or terms, and therefore use them and make them clear that those are the new terms to be considered, and therefore the parties need to comply with them. So absolutely, any change to the contract need to be stated in writing as an amendment to the contract.
Very good. Thank you, Daniel. I see one hand raised. Please, if you don't mind writing the question in the Q&A box. And in the meantime, I will just say, show another slide while we wait for the follow-up question. Yeah, I mentioned we have some guidelines on how to identify these red flags when doing or maybe make background checks. I shared in the chat art links to these resources that we have. They are completely free. Again, you only need to register on our website. And we receive emails from SMEs very often about disputes encountered with Chinese partners. Yes, this slide, we had the Q&A. Yes, while we wait for the follow-up question, I would like to invite you to scan this code and share your feedback with us. It will only take 1 minute. It will really help us to improve what we do, or to have some input on potential topics that you would like us to cover in the future in webinars and so on. Finally, we also have a lot of relevant trainings, training recordings on our website. In the past, we have one on the specific arbitration litigation process. We have also another webinar that we did last year with Daniel, which was also very detailed, and you can refer to that. Everything is on our website and accessible and free for everybody. So please go there. We have received the question in the meantime. Another question, what to do, and this is the last question because we're already late. What to do when you realize that your trademark has already been registered by an unknown Chinese company?
Unknown Chinese company, I guess
I guess it's a company you never dealt with, or it's
okay,
just
okay.
Yeah.
Well, like I said, it's a very good question because actually, this is one of the main issues that foreign companies suffer or face when approaching the Chinese market, and they realize that someone else, and 99% of the cases, it's a Chinese company, has already registered their trademark in China. So what to do? Actually, there's a few tools that we can use. First of all, we need to conduct a very brief investigation to understand who this company is, and define the best strategy we can use to act against them. And basically, there's two tools, or there's two actions we can take. There's an invalidation action we can take before the trademark office in China to invalidate that trademarks. In many cases, based on bad faith grounds, like this Chinese company that registered my trademark did it on bad faith, just trying to take advantage of my reputation or the reputation of my products or my trademark in China. And therefore, we may have grounds to act against it. So we firstly have to invalidate their trademark, and then file an application to register our trademark under our name. That's the action. Those are the actions we can take, and it's a very clear procedure that we can follow, and it is successful in many cases, especially in the last year that the intellectual property system in China has improved significantly. So taking action against the registered trademark first, and then file an application to protect our trademark under our ownership.
Thank you, Daniel. Maybe also I take this occasion to remind everybody that the European Union is funding another project very similar to us. It's called China IP SME Help Desk, which is dedicated exclusively to IP issues. And there are some resources about how to register, protect trademarks and patents and similar. So it's free, it's a great project. I invite you to visit the website. Now I would, we ran a bit late, but I think it was good because we had a lot of questions. Thank you, Daniel, for your contribution to this, to the guidelines, to this excellent presentation. Again, everybody can feel free to reach out to Daniel for any follow-up questions. You can also reach out to us, of course. And I thank everybody for taking part in this. See you next time.
Thank you, Alessio, for the opportunity, and see you next time. Yeah.